A bold move by the government to block an appeal against the ban on Palestine Action has backfired, leaving a trail of controversy and raising important questions about freedom of expression and the law. In a recent ruling, the Court of Appeal has opened the door for a thorough review of the government's decision to ban Palestine Action under terrorism laws. This decision has sparked a heated debate, with implications that reach far beyond the courtroom. The story unfolds. Huda Ammori, co-founder of Palestine Action, was granted permission earlier this year to challenge the Home Secretary's ban. The government, however, attempted to halt this judicial review, arguing that Parliament had outlined an alternative process for appealing banning orders. But here's where it gets controversial. The Court of Appeal disagreed, paving the way for a High Court judge to review the ban next month. The ban, which came into effect on July 5th, criminalizes membership or support for Palestine Action. Since then, over 2,100 people have been arrested during demonstrations, with some protesters facing charges for allegedly showing support for the group, a move that could land them in jail for up to 6 months. The legal battle ministers argued that Parliament had set up a specific process for appeals, but Ms. Ammori's lawyers contended that the unique circumstances of the ban, coupled with widespread public support for Palestine Action, warranted an immediate review by the High Court. They pointed out that Parliament had not explicitly ruled out a faster challenge process, despite creating an alternative, slower one. The Lady Chief Justice, Baroness Sue Carr, sided with Ms. Ammori, stating that the initial decision to proscribe Palestine Action could be lawfully challenged without waiting for the outcome of the longer POAC process. She emphasized that judicial review would provide a quicker means of challenging the order and would allow the High Court to deliver an authoritative judgment on the legality of the ban. The government's response. The Home Office acknowledged the Court of Appeal's decision and promised to carefully consider its implications. They highlighted Palestine Action's escalating campaign, which has included criminal damage to national security infrastructure, intimidation, alleged violence, and serious injuries. The spokesperson emphasized that supporting Palestine and supporting a proscribed terrorist group are distinct actions, and those who support Palestine Action will face the full force of the law. A victory for Palestine Action? Ms. Ammori celebrated the government's attempt to avoid judicial scrutiny as a spectacular backfire. Not only did the Court of Appeal allow her to challenge the ban, but they also expanded the grounds on which she can do so. She plans to present a stronger case to the High Court in November, arguing that the ban is an unlawful misuse of counter-terror resources against peaceful protesters and those opposing the arms trade. This case raises important questions. Should the government have the power to ban groups based on terrorism laws? What constitutes a fair process for challenging such bans? And how do we balance the right to support a cause with the need to maintain national security? These are questions that will undoubtedly continue to spark debate and discussion as the legal battle unfolds. What are your thoughts on this complex issue? Feel free to share your opinions and engage in a respectful discussion in the comments below.